Welcome everyone today to the Law Society. Before we kick off, I'd like to get Tim McCormack up to do the acknowledgement of country.
Thanks, Reggie. We commence tonight's proceedings by acknowledging the traditional owners of the custodians of the land on which we meet. And for those of us members of the panel and live audience at the Law Society headquarters in Hobart, we are on the land of the Muwinina people. And wherever else you are in Tasmania or even on mainland Australia, you also follow these proceedings on Aboriginal land. In acknowledging traditional owners and custodians of the land, I'm acknowledging a pre-existing sovereignty, a sovereignty that pre-existed colonial invasion, dispossession, and sovereignty that has never been ceded. And in our case, in Van Diemen's Land / Tasmania, and in relation to the Muwinina people, they, like many of the other bands of our traditional tribes around the state, were so overwhelmingly dispossessed that we now know of no descendants of the Muwinina. So I can pay my respects to the elders past of the Muwinina people, but not present and emerging. That is a profound loss to the culture and significance of Tasmanian society. Fortunately for us, a remnant of Aboriginal people survived on the Furneaux Islands in the northeast in Bass Strait. And from them, we have a thriving Aboriginal community that is making a tremendous cultural and spiritual contribution to Tasmanian society. When I think about the subject matter of what we're talking about, a war going on in Ukraine following an uninvited invasion by a much bigger power, can't help but think about what actually happened on this territory, especially in the 1820s and 30s. And when I'm talking in a little while about international humanitarian law, about legal protections that extend to victims of armed conflict, I want to acknowledge that that law was never extended to the Aboriginal people of Van Diemen's Land or of any other colony in this country. The prevailing view was that Aboriginal people were less than human. And in our case, part of our history that we must come to grips with, we accepted here, not you and I personally, of course, but the prevailing view here was that the demise and ultimate extinction of our Aboriginal people was inevitable because of their lower state in the created order. That is a shocking part of our history, and very important that we, I think, acknowledge that as we get into the subject matter for tonight. Thank you.
Thank you for the tremendous turnout we've had physically and across Australia and Tasmania, and some people in different time zones that I know. Welcome. For those who don't know, we're in a beautiful building in Hobart, the Law Society building. It's a beautiful sandstone building. It houses the Law Society, but it's also where the Hobart Jail was once located. So I think the irony of a bunch of lawyers congregated in the site of a former jail is not lost, particularly on all those non-lawyers joining us today. Before we start, while we're talking about the building, there's a fire escape here, and there's a door there, and up the stairs you can go and use the facilities if you need. That's the housekeeping. Thank you to the Law Society for hosting this event. Amal, particularly for your organisational skills, logistics and great enthusiasm. Luke, Francesca and Simon Gates, the President, for opening your doors to us. We are so incredibly fortunate to have in our presence and living amongst us world-leading subject matter experts right here in Tasmania, who will help us navigate through some of the facts surrounding the situation in Ukraine. Everywhere we look, there's devastating news of maternity hospitals being bombed, innocent children, civilians dying in the most horrific of circumstances, and millions of refugees streaming out of Ukraine. At this very moment, children are stuck under rubble and Mariupol, fighting for their lives in a war they didn't ask for. Somebody else's war. Sadly, it's not the only conflict raging in the world today, and it's not the only location of a humanitarian catastrophe. As we're inundated with information and pictures about Ukraine in the media and on social media, we turn to our expert panel here today to help us understand the facts. They probably don't need any introduction, but I'm going to do it anyway. Sitting to my left here is Dr. Tamara Wood. Tamara is a postdoctoral research at the Hertie School in Berlin and a visiting fellow at the Caldor Centre for International Refugee Law at the University of New South Wales. She's an expert on refugee protection, forced migration and international law. As an expert advisor and research consultant, Tamara has advised the United Nations High Commissioner for Refugees, World Bank, Platform on Disaster Displacement, Nansen Initiative on Disaster-Induced Cross-Border Displacement, and Institute for Security Studies in Africa. Professor Tim McCormack in the middle. He's a professor of international law and former dean of the law school at the University of Tasmania and special advisor on war crimes to the prosecutor of the International Criminal Court, and is currently serving his third consecutive prosecutor in the special advisor role for some 14 years. He's a world leader, leading expert on international humanitarian law and war crimes, and my dear friend. Dr. Matt Killingsworth at the end. Matt is head of politics and international relations and a senior lecturer in international relations at the University of Tasmania. You may recognise his voice from the radio, as he regularly appears as an expert on topical international relations issues locally, nationally and internationally. And finally, I should probably introduce myself. I'm a barrister at Derwent and Tame Chambers, which is just around the back here. Previously though, I worked as a lawyer for the Office of the Prosecutor at the International Criminal Court in The Hague, where I prosecuted war crimes and crimes against humanity. I joined the court in its formative years in 2007, before the first trial had even started. In the 9 years I was there, I watched the ICC grow before my eyes today. And today the eyes of the world is on the ICC in the context of Ukraine. In my time with the Office of the Prosecutor, I worked mainly on cases emanating from East Africa, but also for a short period on the Georgia investigation, the specifics of which strike some similar chords in what we are seeing unfolding in Ukraine. The format today will start with 10 minutes of opening remarks from each of our panel members on their subject matter, and then I will open it up to questions. So for those people who are joining us online, you can use the chat box function to send your questions through, and we'll endeavour to get through as many of them as we can. For the people in the room, for questions that you've got, please wait for the microphone so the people online can hear, even if we can hear you in the room. So without further ado, Matt, let's start with you. You're probably best placed to talk about the foundation on the history of the conflict of Ukraine, and over to you.
Thanks very much, Reggie, and thanks for the very kind introduction, and thanks for the warm welcome here this afternoon. I was wondering if I should lean that in there or I should come around, or is that all right? I'm at a weird angle, sorry. So for people over there, I apologise. I'm sort of cut off from a quarter of the room. The presentation I'm going to give today in my 10 minutes is a potted history of the relationship between Ukraine and Russia. And it's a presentation that I could start in the 16th century and talk about Imperial Russia. That would send you all to the doors really quickly. So instead, my potted history is going to start at the end of the Cold War and the implosion of the Soviet Union in 1991, when the constituent Soviet republics break up into independent nation states. And obviously one of those is Ukraine. And shortly after the implosion of the Soviet Union in 1991, Ukraine declares independence and becomes an independent sovereign state. This in some ways is reinforced in 1994 with the Budapest Memorandum on Security Assurances. And this document was signed following Ukraine's agreement to transfer all of its nuclear weapons from the Cold War Russian, all of its nuclear weapons from the Cold War, of which it had the third largest stockpile during the Cold War, and transfer them to the Russian Federation. In turn, Ukraine signed the Nuclear Non-Proliferation Treaty as a non-nuclear weapons state. Importantly, as part of the Budapest Memorandum as well, this was signed by the US, the United Kingdom, and Russia, all who committed to honouring Ukraine's sovereignty and its rights to its territory. So as far back as 94, we have a recognition or an understanding of Ukraine as a sovereign independent state. The next moment are the 1994 elections. And so there's a couple of themes here that I sort of want to develop in my presentation. The first is that Ukraine since 1991 has been in a tug of war between the West and predominantly the EU, but also Moscow as well. And the 1994 election is sort of the first realization of how that looks politically and electorally. Presidential election between Viktor Yushchenko, who was the Western-oriented candidate, and Viktor Yanukovych, who was supported by Russia, creates controversy. Yushchenko was mysteriously poisoned. Most people assume it was the FSB, the Russian security forces. Subsequently, they've got form with this type of thing, so I think it's more than likely they did. Mysteriously poisoned before the election. Victory was declared in favour of Yanukovych, the Russian-sponsored candidate, but the election was widely seen as fraudulent. Ukrainians take to the street wearing orange for the so-called Orange Revolution in 1994. By December, protesters were able to force a revote, resulting in a victory for Yushchenko. So again, we've already got these sort of tensions between European-backed candidates and Russian-backed candidates. In 2008, the second theme develops, and this is respects to NATO. So many of you have probably seen that one of the rationale that Vladimir Putin has used for the invasion of Ukraine is that Ukraine represented a security threat because of their desire to join NATO. Sort of the North Atlantic Treaty Organization and the Cold War Western Security Organization. So in 2008, a membership action plan is extended to both Georgia. So Reggie mentioned Georgia already, and there are interesting similarities to Georgia and Ukraine. And at that stage to join NATO. And Putin at this stage makes his opposition to Ukrainian membership known to NATO leaders, at one point alleging to George W. Bush, that Ukraine is not even a real nation state. Again, we've already got this theme developing about the lack of recognition of Ukraine as independent. And subsequently, NATO does not offer Ukraine a map. Skipping forward a little bit to 2014, after promising to work towards a relationship with the European Union, President Yanukovych, who was back by this stage after being defeated and still supported by, is Moscow's candidate, changes political direction and begins to orient Ukraine towards Russia. Some people might remember that Yanukovych had promised a closer relationship with the EU, and the EU had presented a deal for them to have closer relations. Moscow got involved. Yanukovych changes his mind at the last minute, actually comes to a conference, a European Union conference, and fails to sign the paperwork. It was quite an extraordinary moment. So this, combined with the controversial arrest of Yulia Tymoshenko, sparked widespread protests, the so-called Euromaidan. There are protests across the country centering on Maidan Square in Kiev. At least 130 people, primarily civilians, are killed. Yanukovych flees to Russia, and the new leadership commits to orienting Ukraine towards the European Union. 2014 is also significant because this is the year that Russia seizes Crimea, which is sovereign Ukraine territory. And this is indeed, so we might talk about 2022 as the first time of Ukraine invading Russia. Russia, there's a Freudian slip. Russia invading Ukraine. Russia had invaded Ukraine before this. They'd invaded in 2014. And not just Crimea, but also those eastern provinces, Lugansk and Donetsk. We don't have a map. You'll get, okay, there's a map coming. You'll get on the eastern border between Ukraine and Russia. 2019, The current president, Zelensky, wins against another Russian-backed candidate. So again, that theme developing again. Oh, cool, there they are. So the two most eastern provinces there. Zelensky wins. Zelensky's a really interesting candidate. He's a former comedian. He also ran as an anti-corruption candidate, which is interesting of itself. Fast forwarding to 2021, we have the large buildup of troops on the border of Belarus and Ukraine and Russia and Ukraine. Vladimir Putin, in a widely circulated document, claims that Ukraine and Russian peoples are one. Again, denying Ukraine sovereign or independence. By December, as I suggested, tens of thousands of Russian troops are deployed to the borders. Putin issues demands to NATO and the United States. Among these demands is that Ukraine never be admitted to NATO, a request rejected by the Biden administration. 3 weeks ago, which is, I guess, the catalyst to where we've come to now, the Russian government acknowledges Lugansk and Donetsk as independent nation states, and in turn sends in peacekeepers to protect the Russian minorities in those independent states, which bears remarkable similarity to the language that used with regards to Georgia and South Ossetia and Abkhazia in 2008 as well. So there are lots of common themes developing here. Just quickly to wrap up before I hand over to Tim, I think we should acknowledge that the NATO membership fear was a red herring all along, that this invasion has always been about re-establishing the Russian Empire as far as Putin is concerned, and the idea that Ukraine is a part of that traditional part that he views as being part of a Russian Empire, this so-called Russia Mir, or the Russian world. And so again, the themes that are there politically about NATO, the West, and Ukraine in a geographically difficult situation sort of all combine to where we are in this position at the moment. Thank you.
Thanks. Thank you, Matt, for laying that foundation. It's a complex lead up, isn't it? Next, I think let's turn to you, Tim. We're seeing viral social media pictures of road signs which have been altered, city names stepped out for The Hague. Do all roads lead to The Hague, Tim, or is there more to it? The floor is yours,
all
Professor.
your and my roads might lead to The Hague, Reggie, but don't know that all Ukrainian ones do. Thanks very much for the introduction. And I'd also just like to thank Simon Gates as president and Luke Reinberg as executive director of the Law Society for enthusiastically embracing our suggestion that we go for this subject matter. And thanks to you for your interest, both here physically and also online. There wasn't that demand, the decision wouldn't have been so overwhelmingly vindicated. So yeah, thank you. And Matt, I thought it's a great way to introduce some of the geopolitical issues and give us some background. I want to focus on the deployment of military force and international law in relation to it before Tamara talks about international legal aspects of the refugee crisis that's increasing, escalating every day. So in international law, and for some of you, this of course is international law 101, and it's very familiar to you, and others probably less so. So for those of you for whom this feels like it's just going over same old, please bear with us. In international law, we distinguish between what we call the jus ad bellum, the law about force, and the jus in bello, the law in the context of exchange of military hostilities or in the context of armed conflict. The jus ad bellum, the law about the circumstances in which states, independent sovereign nation states, are permitted to resort to lethal military force, is a very important question or set of issues, but we distinguish that question of who is the aggressor, who is defending themselves, from the law applicable in the context of armed conflict. So I'm going to deal with the two separately, because irrespective of Russia being the aggressor state, Ukraine engaging in self-defense, both or all parties to the armed conflict are bound by the same body of rules: international humanitarian law, law of armed conflict, law of war, all synonymous terms, the jus in bello, when it comes to the conduct of hostilities in the armed conflict. So in relation to the jus ad bellum, it's a core principle of the United Nations, the post-World War II multilateral security apparatus, that sovereign nation states are prohibited from resort to lethal military force against another sovereign nation state. And with two key exceptions referred to in the UN Charter. The first exception is the collective security mechanism of the UN Security Council. So under Chapter 7 of the UN Charter, particularly Article 41, the Security Council can authorise lethal military force in response to an act which constitutes a threat to or breach of international peace and security. Here, of course, Russia as a permanent member of the Security Council exercises a veto in respect of any Security Council, any substantive measures by the Security Council. The second exception in the UN Charter is Article 51, the right of states to use force in self-defence, where they are the subject of an attack, an armed attack, or the threat of an imminent armed attack. Now, interestingly, President Putin has not just said to hell with international law about the use of force. I don't care about it, or however you say that in Russian. My language skills aren't that good. But instead, he has referred to a number of arguments in an attempt to justify the Russian invasion. This is all from his speech on the or an English translation of his speech on the 24th of February before the invasion actually commenced. He talked, amongst other things, about Russia's future and the importance of preserving Russian ethnicity in those jurisdictions where it was being not just ignored, but trampled on and persecuted. So there was a sort of a national self-defense claim being made by President Putin. We have the right to invade, or we have the right to use this, undertake this special military operation to be able to shore up the future of Russia and Russian culture and identity. Then there's a sort of collective self-defense argument that he raises, and this really picks up on the point that Matt was making. The Russians recognized Donetsk and Luhansk, the two most eastern provinces of Ukraine, as sovereign independent nation states, and then said they were now needing to deploy peacekeepers in self-defense of those two states whose Russian people were being persecuted, or the subject of genocide, in fact, is what President Putin claimed. That's a very interesting claim. And in response to that claim, the Ukrainians initiated litigation at the International Court of Justice in The Hague. The ICJ just being important to distinguish from the ICC, the International Criminal Court. The International Court of Justice decides international disputes between sovereign nation states. And there is a particular clause in the Genocide Convention, the 1948 Convention on the Prevention and Punishment of the Crime of Genocide, which gives to the ICJ jurisdiction over a dispute between states parties to the treaty about interpretation and application of the treaty's terms. So Ukraine is saying this is a complete furphy, this argument, and we want the ICJ to declare it to be so. So that's, if you've read about the initiation of litigation at the International Court of Justice, that's what it's all about. In terms of multilateral responses to Russian arguments and, of course, Russian action, the Security Council did meet in emergency special session and put a draft resolution condemning Russia's action to the vote, but Russia exercised its power of veto. In response, the UN General Assembly was called into emergency special session, which in 77 years of UN history has only occurred on 11 separate occasions. It's not something that happens regularly. The General Assembly meets for 3 months every year in New York, usually in New York, between September and early December. But it can be called into emergency special session. You can imagine it's a huge logistical exercise to try and get 194 member states together to discuss an issue of profound international concern. But that happened in New York just a couple of weeks ago. And by an overwhelming majority of 141 member states of the UN voting yes and 5 voting no, the rest abstaining, the General Assembly reaffirmed the sovereignty and territorial integrity of Ukraine and deplored in the strongest possible terms the aggression of the Russian Federation and the serious violations of international law that it had perpetrated. Interestingly, in relation to the international crime of aggression, the major focus of both the Nuremberg and Tokyo war crimes trials post-World War II, the International Criminal Court has jurisdiction over the crime, but in very narrow circumstances. If you look at the definition of the crime in Article 8 bis of the Rome Statute, it's pretty difficult to make any sort of argument that what Russia has just or is currently perpetrating is not an unambiguous and clear perpetration of the international crime of aggression. But the court only has jurisdiction where both the aggressor state and the state, the subject of the aggression, are states parties to the statute and have accepted, opted in, if you like, to the exercise of the court's jurisdiction over this particular crime. This is a very different jurisdictional mechanism than for the court's exercise of jurisdiction over the other crimes, genocide, crimes against humanity, and war crimes. Now, neither Ukraine nor Russia are states parties to the Rome Statute, so the court does not have jurisdiction over this alleged crime of aggression. And instead, you may have heard Gordon Brown, former Prime Minister of the UK, and a number of other international leaders and some leading international law scholars, Philip Sands at the Bar of England and Wales, a very good example, arguing that what the international community should do is establish an international tribunal ad hoc to try the crime of aggression being perpetrated by Russia. And that's a very interesting proposal. And from my perspective, no impediment in the law to allowing that to happen. We can maybe talk some more about it in question and answer. Let me move, for the sake of time, I'm already close to 10 minutes now, to some observations about the jus in bello. Here, the International Criminal Court does have jurisdiction over war crimes and or crimes against humanity. And that's interesting because although neither Ukraine nor Russia are states parties, and the UN Security Council is obviously precluded from referring the Ukrainian situation to the court, and that would give the court jurisdiction. Ukraine has, as a consequence of Russian invasion of the Crimean Peninsula in 2014, made a declaration, an ad hoc declaration under Article 12, paragraph 3 of the Rome Statute, accepting the court's jurisdiction over conduct occurring on its physical territory. And that declaration has no end date. It's still valid. The Ukrainians have confirmed that it's still valid. And on the basis of that declaration, the prosecutor of the International Criminal Court said he would now seek approval to open a formal criminal investigation. It could have happened two ways. One, by going to the pretrial chamber of the court, a panel of 3 judges, and seeking their approval, or having a state party refer the situation in Ukraine. 39 countries, including Australia, all states parties to the Rome Statute, within 24 hours issued the referral that he was asking for, because that's a hell of a lot more expeditious. And so on the basis of that referral, he announced, I am opening a formal criminal investigation, and a team of investigators went from The Hague last Wednesday of last week, not yesterday. Now, that's all fascinating developments, of course. What are we talking about in terms of sorts of conduct that could constitute war crimes? Well, there will be issues about treatment of POWs and detainees, but right now the media focus, and rightly so, is on targeting decisions by the Russians. We've had a lot of news coverage in the last 24 hours on the attack in Mariupol of the maternity and children's hospital there. And that looks like a war crime. It is a war crime to intentionally direct an attack against a hospital. Hospitals are protected with a special layer of legal protection as immune from attack in armed conflict. And of course, knowing that the hospital is full of civilians, it's also a war crime to intentionally direct an attack against civilians. Even more reprehensible, allegedly, because there was supposed to be a ceasefire to allow civilians to flee the fighting, and apparently, or allegedly again, the Russians used the opportunity as civilians trying to flee Mariupol to actually breach the ceasefire and undertake direct attacks. Now, I can't say unequivocally that's a war crime, because there's some things that the prosecution of the International Criminal Court would need to prove beyond reasonable doubt. Are we absolutely sure that, do we have evidence that will establish to the requisite burden of proof that this hospital was intentionally targeted? Were there any military facilities or personnel of the Ukrainians in the same region or in the same vicinity as the hospital? Is it possible it was inadvertently hit in the crossfire, if you like? What else was going on at the time? What evidence will we be able to adduce that the Russians deliberately targeted it? There are issues about heavy bombardment, about artillery, and also aerial bombing of residential areas. The siege of cities, the violation of ceasefires. So yes, we'll agree to a humanitarian corridor, we'll agree to a ceasefire, then firing on civilians as they act on the basis of the assurance that they're free to leave the particular city. There are also questions about choice of weapons. There have been allegations of the use of cluster munitions. UK Ministry of Defence confirmed in the last 24 hours that the Russian Defence Ministry has conceded that it's used thermobaric weapons or fuel air explosives. There are great fears about the use of chemical weapons and even of possibility of nuclear weapons, especially if the siege of Kyiv doesn't result in the fall of the capital expeditiously, and the Russians get frustrated about how long it's taking. Just one final observation about establishing the crime base of war crimes or crimes against humanity occurring in Ukraine is one thing, but one of the challenges the International Criminal Court will unquestionably have is to go beyond the establishment of the factual evidential material that these crimes have been perpetrated, and then to tie criminal responsibility to particular individuals. Who are the most responsible? Those who physically perpetrate the offences, those who order them to be conducted, those who are refusing to exercise their effective authority and control to prevent these atrocities occurring. And we know from past experience with international trials, Reggie knows better than anyone, how challenging that often is to attach individual criminal responsibility. Thanks very much.
Thanks, Tim. It seems that the Special Advisor on War Crimes to the Prosecutor of the ICC has a lot of work ahead of him.
He does.
Finally, Tamara, we'll move on to you next. One thing that we can be sure of is the humanitarian fallout and the masses of refugees pouring out of Ukraine. When we started preparing for this forum last week, there were reports of 1 million refugees having fled Ukraine. In a week, that number has doubled and it's still rising. Tamara, the floor is yours.
Thank you. So I'm going to talk about international law frameworks for protecting people who are forced to flee. So international refugee law, concepts like temporary protection, some international human rights law and so on. I guess I want to preface this with, usually we use these instruments as a kind of stick to beat states that are not welcoming people who have fled. And in this case, in fact, in Europe at least, we have seen more open borders and a more welcoming reception than we've seen for a very long time for people forced to flee. So I'm somewhat reluctant to start making clever legal arguments about whether people are refugees or not and so on in that context. But I do think these questions are important, partly because not everyone is receiving the kind of warm welcome that is, around on the media and so on at the moment. And also because though we have this sort of reception at the moment, that may not stay the same over time. That may not be the same outside of Europe. And as I said, it may not be the same for all groups. So I think it is quite important to think about the international law principles and frameworks that guide or obligate states to respond in certain ways to people when they flee. I'm going to address 4 frameworks or concepts: international refugee law, international human rights law, but particularly the principle of non-refoulement, temporary protection, which you've probably heard about in the news, which has now been applied within Europe, And then I'll look very briefly, if I have time, at responsibility sharing in international law and what this all means for states like Australia or Canada or other states around the world who are not necessarily next to the crisis, but have a role to play. I do have a few slides that I prepared, which hopefully might be on the screen here, streaming out. I'll keep talking, and they just have, because I'm going to go through a few different definitions, it's a bit of a mind jumble if you can't look at them, but I'll start talking and I'm sure we can catch up. No problem. So everyone at home, you get the benefit of the words on the screen. So I'll begin with refugee law and the 1951 Refugee Convention. Some of you may already be familiar with the definition of a refugee. A refugee under that instrument is a person who has a well-founded fear of being persecuted for one of 5 particular reasons: race, religion, nationality, membership of a particular social group, or political opinion. So there's a number of different components or criteria of eligibility to show that you are a refugee. In this particular case, a fear of persecution, which is usually understood as serious harm, would not be difficult to establish in Ukraine. That your fear is well-founded, that you are likely to experience a risk of serious harm is probably also not difficult to establish, even in parts of Ukraine that are not being directly affected by conflict. The threshold doesn't mean that you need to show it will happen, but only that there's a real chance that it will happen. And this has been interpreted as being a lower threshold than it being more likely than not. So this is not even a 50% threshold. The challenge in situations of armed conflict, like the one in Ukraine, of establishing refugee status is what we call the nexus clause, is showing that the risk of harm to you is for one of those 5 reasons: race, religion, nationality, and so on. In a similar conversation to this one last week, I said, of course, these people are refugees. You know, it's not difficult to show that in this case, people are at risk because of their nationality, or alternatively, because of an imputed political opinion that is, you know, an opposition to Russian rule, for example, in Ukraine. Since that time, I've heard a number of commentators and refugee law scholars say, no, these people are not refugees. In fact, there's quite a divide in opinions. This is not being discussed a lot at the moment, largely because of temporary protection having been invoked in Europe, which obviates the need to look at this, and I'll come to that. But this is the kind of question that is going to arise if or when temporary protection comes to an end, particularly if the war is ongoing. If or when people come to countries like Australia under family reunification visas or holiday visas or study visas, and those visas come to an end and they're expected to go home and so on. There's been a lot of analysis, particularly in recent years, of how to determine refugee status in a situation of armed conflict. Just being in the wrong place at the wrong time does not make you a refugee. You need to show that link to one of those protected characteristics. Now, for some groups in Ukraine who would be particularly or have an increased risk over others, so for example, LGBTQI individuals might be able to make quite a good argument that they could be individually targeted because of their membership of a particular social group, and therefore quite easily qualify for refugee status. But for others, this could prove to be a difficult question. And if you pay attention to the news, you'll notice UNHCR, and I checked this today, is not calling people refugees. They're talking a lot about the crisis, but they're not describing people as refugees. They're talking about people who've been displaced. There are also exclusion clauses for refugee status. So that is, even if you meet the basic definition of a refugee, if you fall within one of these exclusion clauses, you can be denied protection. And some of those exclusion clauses include having committed war crimes, crimes against humanity, and so on. This could be relevant, for example, for Russian deserters who perhaps decide to abandon the project and seek protection elsewhere. It could potentially even be applicable to Ukrainian fighters if there was evidence that they'd engaged similarly. Interestingly, if anyone flees from this crisis to Africa or Latin America, there's a much broader definition of a refugee that extends to people fleeing events such as external aggression, occupation, foreign domination, events seriously disturbing public order. So your path to refugee protection in those places would be much clearer. Being eligible for refugee protection means principally that you're protected from being returned to the place where you would be at risk. So it's I guess, an exception to that general right of states to decide who gets to enter or stay in their territory. It also precludes rejection at the frontier. So it also applies, for example, at the border of Ukraine and Poland. So where there have been stories, particularly of non-Ukrainians, so students or people on other visas from countries in Africa, Asia, and so on, not being allowed to leave, that could count as refoulement under international law. Secondly, international human rights law extends the principle of non-refoulement beyond people who meet the refugee definition to other people who are at risk of certain serious human rights violations, in particular, violation of the right to life, the right to be free from torture or cruel, inhuman or degrading treatment, and so on. The principal difference here is that there's no nexus requirement. You don't need to show that the risk of human rights violation is connected to your race, your religion, your nationality, and so on. So I think it's hard to imagine that anyone fleeing Ukraine at the moment wouldn't be able to make a decent claim to one of these human rights violations. This kind of protection works a bit similarly to refugee protection. You know, it protects you from being returned. Depending where you are in the world, it gives you some sort of legal status. It's often referred to as complementary protection or subsidiary protection. And in Europe particularly, it's subsidiary protection. And Europe has something called the EU Qualification Directive, which has another title that goes for about 5 pages, that implements subsidiary protection. And it applies to people who are at risk of various things, including serious and individual threats to a civilian's life or person by reasons of indiscriminate violence in situations of international or internal armed conflict. And that, I'll go to the, I think I've got that on the next slide. Oh, it's not catching it. No problem. I think you get the idea. So if you're not eligible for refugee protection, particularly in a situation of armed conflict where it may be difficult to establish that link to your personal characteristics because it is more widespread and indiscriminate, then subsidiary protection in Europe, or complementary protection as it's called in Australia, may be available to you. Of course, human rights is not only about the principle of non-refoulement. There's all sorts of other human rights obligations that states owe, not only to their citizens, but to all people who are within their territory or jurisdiction. I'm going to come to the third one now, which is temporary protection. You've probably heard quite a lot about this in the news. This is different or separate. It sort of works in a similar way. You know, it's something that can be given to non-nationals to allow them to stay, to be protected, but it is separate from refugee protection or subsidiary protection. And the main purpose of temporary protection is to confer protection on people very, very quickly, where you don't have time, in this case, for example, to individually sit down with 2 million people and ask them, do you fear persecution? Is your fear well-founded? What are the reasons for it? And so on. So it's particularly intended in situations like this where you have a very large number of people fleeing a particular geographical area or a particular country, where it's quite obvious why they're in need of international protection. But the real key is that it would overburden your system to try and, you know, process these people via usual refugee status determination or subsidiary protection status determination mechanisms. In Europe, temporary protection applies, can be applied to refugees, but also to people at broader risk of things like armed conflict. And the EU Temporary Protection Directive applies in situations of mass influx. There is a definition of mass influx, but it's quite vague. But again, that key is that the systems would be overwhelmed if states tried to process this via refugee protection mechanisms and so on. The thing that is different about temporary protection compared to, say, refugee and international human rights law is that it's not, the temporary protection directive is not a matter of binding international law in the same way, and it's not self-executing. So the Temporary Protection Directive has been around since 2001. It has never been invoked before the current situation. It was not invoked or applied in 2015 during the large-scale influx of particularly Syrian but other refugees into Europe, despite the fact that the European Parliament called on states to apply it at that time. And in fact, following that situation, everyone thought that the Temporary Protection Directive was dead and buried, and it was on the cards to be repealed because it was seen to be pretty useless. So, if we couldn't apply it then, what was going to be the point? So it's been a great surprise, and in many ways a very good surprise to see states invoke this. What it means is that Ukrainians fleeing to countries who are applying the Temporary Protection Directive, so EU countries, are able to basically get an instant form of legal status, temporary protection that lasts for up to 3 years. So the initial period is 1 year, then there's various ways that it can be extended. And that entitles them to a range of rights to things like housing, social welfare systems, healthcare, education for children, and so on. The rights under temporary protection are generally less than the rights under refugee protection or under complementary or subsidiary protection. So it's kind of an instant form, but a slightly lesser form of protection. One of the really important things about temporary protection is that it cannot detract from, or it can not be used by states to try to circumvent their obligations under refugee and human rights law. So a person who benefits from temporary protection is, or at least should be, still entitled to apply for refugee protection or subsidiary protection. In practice, what people would tend to do would be to do that at the end of the temporary protection period. So that's why I say questions about refugee status and so on are ones that, especially if the war goes on for a long time, we might see delayed until, in 3 years' time, there might be relative calm to what we're seeing now, but still not a great situation where we'll start to have more difficult conversations about eligibility for refugee protection. There are other forms of temporary protection or humanitarian protection. You might have heard of something called temporary protected status in the US, which was just invoked and applied yesterday, I think, which is another kind of status that the US has for Ukrainians, but that only applies to Ukrainians already within the territory. So it's a sort of a suspension on people being obliged to go home. I think it'll apply for 18 months, but it can be reviewed again. The final thing, which I won't talk too much about just for the sake of time, is the principle of responsibility sharing or burden sharing. So far, I've been talking about frameworks that really only apply once a person reaches your territory, the territory of a particular state. So primarily that is the neighbouring states to Ukraine and then other European states. But of course, people may travel or seek to travel elsewhere as well. There is no binding principle under international refugee law relating to responsibility sharing. So there's nothing that obliges states that are not directly receiving refugees to their territory to do anything to help. There's mention of it in the preamble to the 1951 Convention. There also in 2018, states concluded something called the Global Compact on Refugees, which you might have remember hearing about at the time. And in that, states pledged in a non-binding instrument to create more third country solutions for refugees. And the principal third country solution for refugees is resettlement. So UNHCR principally manages a resettlement program that involves individual refugees who are in other countries, usually they're sort of frontline states hosting the largest number, to be resettled to a country like Australia or New Zealand or Canada, to be some of the countries that do have resettlement programs. This is a voluntary program. There's no obligation to do this under international law. Australia historically has a reasonable record at this, and they have at times, particularly for Syrians and Iraqis, say several years ago, increased or added to the number of people that they resettle in response to a crisis like this. Australia has not done this at all for Ukraine, despite some of the clever wording that they've put out there about being ready to receive people and so on. But it is quite likely they will resettle people, but probably within the existing quota that they manage each year anyway. But they could increase that, and they have done that before. Happy to expand on that if needed. Thanks very much.
Thank you, Tamara. I've learnt that I should be saying displaced persons and not refugees at this particular point. So thank you for the correction there. I will open it up to questions now. Maybe I'll start with people in the room. If anybody has a question for anyone on the panel. Anyone with a question? Just over here, if you just wait for the microphone.
Thank you. Patrick O'Connor from the Tasmanian Refugee Legal Service. Just had a quick question about the different approach that the Department of Home Affairs have taken to these cases. What we've seen in the last week or so is that a number of people have been granted visitor visas, tourist visas to come to Australia, the Ukrainians. Generally, they've often failed under genuine temporary entry requirements, but it's been quite a different approach this week where some of these visas have been granted to allow people to come here onshore. Just wondering, any sort of general comments about that approach?
Sure.
Thank you.
Shall I answer that straight? And then,
Please,
yeah,
thank you.
That's a great question. So I said resettlement is the main mechanism by which countries like Australia can accept refugees. The other mechanism, which is increasingly being pushed by UNHCR, is something called complementary pathways. And this is basically where states use non-refugee or non-humanitarian pathways, things like visitor visas, student visas, labour migration programs, to provide access to those refugees who qualify for them. The idea is that if we do more of this, and this is something that's included in the Global Compact, if we do more of this, we relieve the burden on the more refugee-specific pathways and thereby increase the space. You know, that not all refugees are necessarily in need of a specific humanitarian solution. Some of them have great skills that could be really useful and so on. And obviously in an immediate crisis like this, a very quick way to relieve the pressure on the protection sort of system is to approve those visas that are sitting in the queue. So it's not that's certainly not a bad thing, that's great. The question is what happens then, because they're very precarious forms of status to have. They're pretty much they are always temporary. There's no specific guarantee of what would happen at the end of that visa. Now, once a person is in Australia, they could apply for asylum, but then they would be faced with those very technical questions about whether they're a refugee, and they're questions that we would expect the answers to change over time. Like, it's really going to depend what happens. It's a forward-looking test. It's not about what happened to you before you left. They often don't provide, or they nearly always don't provide, the kinds of social supports or financial assistance or access to language assistance and so on that someone who is resettled here is provided. You know, being resettled to Australia as a refugee is pretty good. Like, it's very well supported. There's all sorts of supports in place, but people arriving under those visas would not automatically qualify for any of those. I mean, maybe something could be put in place to help supplement that. So I think it's great as an immediate thing, but it's not going to be a long-term solution. And one of the real risks is that countries may be like, and in fact, we've seen our government already, we've approved 1,500, visa applications, and they put this forward as their contribution or their meeting of the international protection needs, when actually it's not really. So it can be, if doing that somehow helps them to not do the things that they should or could be doing that actually are more principled and more effective, then that's a problem.
Thanks, Tamara. I have a question that someone gave me prior to this, and I think it's for you, Tim. What is the difference as a matter of international law between Russia's invasion of Ukraine and the US invasion of Iraq?
I really like that question, because I think that I was one of multiple colleagues, 45 of us, that signed an open letter to the Fairfax Press decrying Australia's joining of the so-called Coalition of the Willing to invade Iraq way back in, what if it was 2003. And I feel like, having participated in that, we're now in a much more challenging position to be able to pull out all the principled arguments for why President Putin's just egregiously violated international law. In fact, in his speech on the 24th of February, he says precisely that, not targeting Australia, but the West engaged in the bombing of Kosovo in 1999, a province of Serbia. They engaged in the invasion of Iraq. They've engaged in all sorts of their own violations of the very principles they claim that we're violating. I mean, of course, those violations don't make his violation justifiable, but it does make it a lot harder for us to get on a high moral horse, get on a high moral ground and pontificate about, you know, the laws that he's breaking. I think there are some differences between the Iraqi situation and Ukraine, but when it comes to the basic rules about the prohibition on the use of force, unless you've got one of very few limited exceptions, I'd have to concede that they are both violations of the system.
Thanks, Tim. I've got a question online now. So what do you call someone who doesn't fall within the category of refugeehood, but comes under the EU qualification directive? That one's for you, Tamara.
Sure. Thanks for the question. Definitions and terminology is one of my favourite things. The short answer is you'd probably call them a beneficiary of subsidiary protection or a beneficiary of complementary protection. They don't sort of have a title the same as refugees. And just to round that out, the qualification directive, the EU qualification directive, deals with both refugee protection and subsidiary protection. So.
Thank you. Anyone in the room?
Bit hard to call them beneficiaries, isn't it, in the current circumstances?
Yes.
When your country's been invaded, to talk about benefits is, yeah.
Over here.
So this is a question that probably maybe Matt, Tim and Reggie could chime in on, but what I'm wondering is, I guess, what are the parallels between this and the invasion of Georgia and the annexing of the Crimea? And I guess what I'm really driving at is, should we have seen this coming, or is this a bit of a modus operandi for Putin?
So the commonalities are that Putin claimed that they both represented an existential threat. And so both through the 2008 NATO meeting and this was very clear in the way that the Russians invaded Georgia, it wasn't just the protection of South Ossetia and Abkhazia. They went in to the capital and they destroyed the Georgian military, very much so to make that they couldn't join NATO. Whether you see this coming, I think what this demonstrates is that the toolbox is empty in some respects in response to violent despots, which Putin is. There's a limitation, especially when said violent despot is a permanent member of the Security Council, has nuclear weapons. And so the toolkit of what the West can do, even if they did see it coming, is sparse. And so there's also another aspect to this, and this is not in any way blaming the West for this. But at the end of the Cold War, the prevailing ideology of neoliberalism and that engaging with especially Russia and China and drawing them into international trading organizations was the way in which you could encourage them to become liberal democracies. Both of those particular countries have gone, we're going to sell you stuff, we're going to buy your stuff, but we're not going to have a bar of the liberal democracy part. We're not going to be one of those post-91 peaceable countries. And so there's also a failing, I think, generally in Western hubris in some respects about their interpretation of winning the Cold War too. So whether you saw it coming or not, I think it's if you did, what can you do is the other part of that.
Anything you want to say, Ricky?
No, it's covered it. I'll move on to the next one. Was there a question here? Yes.
So at the start of the invasion, we heard the term special military operation. From a legal perspective, apart from perhaps optics externally, is there a reason why that term is being used, and does the ICC see through the colour of special military operation?
Yeah, thanks. I'm going to go for that.
It's all yours, Tim.
Can I go?
That's all
Can I
yours.
have a postscript?
You want to go first?
No.
I don't want arguments in the panel here.
No.
We're a harmonious panel.
No, it's special military operations. It's a lot more palatable terminology than invasion. And I don't think anybody who has any potential decision-making capacity is fooled by that at all. So, yeah, I think that's probably enough for me.
Matt?
You go for it.
Back to the question about Georgia and Reggie, you'll remember this. The Russians invoked the responsibility to protect doctrine in 2008 as well in South Abkhazia and South Ossetia. And on your question, I'm somewhat surprised that they used special military operation and didn't use the terminology of R2P, despite the fact that it was obviously would be deeply flawed and isn't in any way sort of. But it's interesting in both that what that says about the R2P doctrine, but in turn as well, the sort of the language that is being utilized instead for the supposed protection of Russian minorities within those areas.
Yeah. Just on the R2P, I mean, my observation is that from 2011, in Libya, was it not 2011? What was the year? Was it? So the Russians allowed the critical resolutions 1973 authorizing military force to prevent the slaughter of the civilian population of Benghazi, the second major city in Libya. And then and the language of that resolution, if you read back through it, it's like a textbook example of the growing importance of responsibility to protect as a lawful justification for Security Council authorization of military force. The Russians were absolutely furious that from their perspective, that limited mandate was then manipulated and exploited by NATO to end up overthrowing the Gaddafi regime and putting military forces on the ground, both of which they were completely opposed to from the outset. And I suspect that the Russians have made a commitment since then that we will never allow a Security Council resolution to use that language again. And so that might be the explanation. I'm not saying it is. I don't know the mind of Vladimir Putin, but maybe that's part of the explanation for choosing some other relatively nondescript terminology this time around.
And actually that follows on to the next question, which is online, and that is, given the notorious problem of permanent members of the Security Council vetoing resolutions against themselves, is there any serious pressure within the UN community to remove that right of veto by permanent members? And is there any realistic prospect of change in this regard? No. I think that's a one answer question.
Amendment of the UN Charter is subject to the veto of the Security Council. I mean, any amendment of the UN Charter has to have a 2/3 majority of the General Assembly and has to be approved by the Security Council, which means at least 9 affirmative votes and no negative votes of any of the permanent members. Which of the 5 permanent members? And I'm not singling Russia out or China. There's no way the UK or France would allow an amendment to the Charter that removes the veto power. It's not going to happen.
France probably should remove itself.
They should. I mean, we can say as much as we want to about what should happen, but it isn't going to.
It's really tricky. It's not to do with, no, don't panic. It's not, just, can you please?
Just the microphone. Yeah, just for the people online.
You're going to see why that was unnecessary. Can the people on the panel stop putting their masks on and off? I think it's okay if you just leave them off. I don't want to, even in the Supreme Court, they'll let us take our masks off. They won't let us do it anywhere else. But if you're talking, it's just, I just find it really distracting.
See, when Jess has
It's like a
spoken,
show.
we act.
So do I.
Yeah.
I know I kept mine on. It's horrible. My glasses are fogging up. Anyway.
Thank you. Thanks.
Jess
don't
is
have
the boss of
anything
Derwent and
terrific.
Tamar Chambers, so we all do what she says.
Appreciate it.
Is there another question? Now, there was a question down here in the room. Yeah.
Thanks for that. My question just regarding what the West could have potentially done, having seen this arising. You mentioned, Matt, that back in 2008, the opportunity for the Ukraine to become part of NATO was not followed up. No map was provided. What was the reasoning behind that, given the position of Ukraine and potential for NATO to occupy that position? Why wasn't that acted on?
because they didn't fulfill the criteria for entering NATO. It was pretty much that straightforward. And then as time has gone by, there has been the ever-present threat of Russia and that hanging over Ukraine and that hanging over NATO as well. And if you look at that map, I'm sympathetic in somewhat to Russia not wanting a NATO state on its borders. I am sympathetic to that. But there's also a great degree of hypocrisy, especially coming from people like Sergei Lavrov, who talk about the sovereign right of Russia to make decisions about its own security, but then at the same time denying Ukraine that. And so the language has been extraordinary around this. And the EU has also been, I think, somewhat complicit in this, in sort of almost treating Ukraine as a buffer state in some respects, and sort of having those near Eastern European policy sort of through there of not extending membership, but sort of keeping them at arm's length, but also dangling regular carrots towards them as well. So again, I'm not apportioning blame, but lots of the policies are sort of being hazy. I hope that answers.
And that can,
There's quite a few NATO members currently who are relieved that Ukraine is not a NATO member, because then there'd have to be an invocation of whatever it is, Article 5. And I suspect the Estonians, the one country that does share a border with Russia that is a member of NATO, it'd be a bit toey about their situation.
But further to that, the whole exercise for Russia has been counterproductive, because you've now got countries, the Finns are talking about joining NATO.
Yeah.
And this is extraordinary.
Yeah.
And so you've got this situation where it was believed that NATO was weak, let's take advantage of them. And what this has done is united a previously sort of divided NATO, and in lots of respects, the EU too, which was hemorrhaging over various issues at the moment. And they've united both of them, where they sort of believed that they were both weak to take advantage of them.
And if Trump had been re-elected for a second term, NATO would probably be all over.
don't
I mean,
go there,
No,
Tim.
that's not it's a hypothetical, I know. It's one
an
I'm
ad-
relieved didn't happen.
Yes.
Multiple reasons.
Can we come back to that one later?
To Trump.
Guess
Not
this
until
one's fun.
Not until there's drinks.
Okay.
That needs a drink. I think that answers one of the other questions online about NATO. There's an interesting question here, actually, which probably goes to reparations in a way, but it says, I've seen recent commentary suggesting that seized Russian assets should be used to pay for reconstruction in Ukraine post-war. Anyone have thoughts about the legality or even possibility of that happening when we have the reparations and trust fund system at the ICC, but that's right at the end? And you know, if there is a conviction.
Yeah.
But what are your thoughts on that, panel?
It's a great suggestion.
Isn't it?
Those oligarchs are worth a fortune.
They are.
But I don't know about the legality of it.
Mm.
Yeah, I'll do some work on that. Take that question on notice.
Take it
Come
on
back to you
notice.
in a couple of weeks.
Thanks. Anyone in the room with another question? Just over there. A minute. Stand down.
Forgive me for this one, it's a bit of an incomplete thought, but of course I'm just opening this up for a comment. I understand that Ukraine has put the word out to say that we will issue visas for people who will come and fight for us, but they're not necessarily putting it out there to say, well, we'll pay you. So I understand they wouldn't necessarily fit the definition for mercenary, but I mean, perhaps how should we be looking at these people and maybe who owes them a responsibility moving forwards?
Terrific question.
Yeah, who wants to take that one? You take it, Tim.
Well, you want to have?
No, you take it.
Anyone else?
Go afterwards, because I think this is really important about the protection of mercenaries in international armed conflict.
Yeah.
versus non-international.
Sure. There are provisions in the Commonwealth Criminal Code Act of 1995 on foreign incursions. And the legislation used to be limited to going and fighting with a non-state armed group against government forces. So if you actually went and fought on the side of government forces, you couldn't be prosecuted under that legislation. And I think that the Commonwealth changed that once they started to have some experiences of people fighting with governments they didn't want to be seen to somehow or other be accepting of. But I'm not sure. I'm not really up on the current state of the those provisions of Commonwealth Criminal Code.
So there's also an interesting sort of debate, although this isn't a non-international armed conflict, so it doesn't really matter in that respect, but international humanitarian law provides different protections of POW status for mercenaries in international armed conflict and non-international armed conflict. So it's interesting that there's been commentary, especially from the Russians, arguing that foreign mercenaries wouldn't be offered POW status as far as they were concerned. Now, we know that that's a violation of international humanitarian law, and we also know that any all belligerents taking part in hostilities are protected under IHL. But it was the POW one for mercenaries, the commentary that I saw recently, might have been on Opinio Juris website. I found really interesting.
I just wanted to add, it's not a direct response, but just because we haven't talked about it already, the people going the other way. So as we know, men, I think aged 18 to 60 can't leave, are prohibited from leaving the Ukraine. And there are some reports of them actually being prevented at the border. I'd be quite interested, Tim, in if you have a take on those people, but I think that's another interesting group to think about the protection if or when they leave, because I think that will raise different questions as well. But I don't know, Tim, where does that sit in international law? Because as I understand it, they haven't been conscripted necessarily.
Yeah, but I think from an international legal perspective, we allow conscription. It's not a violation of international law for a sovereign nation state to require a certain group of its nationals, sometimes also permanent residents perhaps, but a certain group of its nationals to do a particular period of national service without being able to get out of it, maybe with limited exceptions. So I don't know whether there's a specific prohibition against it, but I imagine from sort of those first principles, if you like, about sovereign discretion, that if it's possible in international law to conscript, it must also be possible to prevent departure of those able to or deemed able to be part of the fighting effort. So, yeah, I mean, of course it raises some moral challenges, but I think from a legal perspective, it's probably okay. I know of no prohibition against it.
I don't know, human rights law, you have a right to leave your country. And I think that for conscientious objectors, conscientious objection, there's a right to conscientious objection, fairly recent one, I think, in human rights law. So I wonder where that comes in. But I think, I mean, it's very well established under refugee law that conscientious objection, if you were going to be subject to punishment that amounted to persecution for not participating, would give you a refugee claim. But I'm not quite clear if they're not being made to fight, but they're still not being allowed to leave a conflict. So I don't know, I think there's some complexities there.
Sorry, Matt, you were going to...
Just a quick one. I understand why Zelensky has called for able-bodied men to return to Ukraine and fight. I get that. There's a degree to which I'm also uncomfortable with it, though, as well, that the idea of untrained combatants in fighting a war is problematic. Again, though, I get why. There's the appeal to the national, the sort of the appeal to nationalism is a strong claim. But yeah, the practicalities of it, I'm relatively uncomfortable with.
Especially Matt. I mean, I think that's a great comment to make, great observation to make. I'm especially thinking about the fact that as a consequence of that policy, those who do actually take a direct part in hostilities have forfeited their protection from attack. From a Russian perspective, they are legitimate military objectives. So that's high stakes, isn't it? I mean, it's high stakes to have your country invaded, of course, but yeah.
I have a question from me, actually. I saw a few days ago that the German prosecutor's office in Karlsruhe had opened an investigation, which they've done in other matters. In fact, they've successfully prosecuted war criminals, including someone from the FDLR who we at the ICC couldn't do, and I put my hand up. I was on that case, but maybe Tim, you could speak a little bit out to universal jurisdiction and how that actually works in the context of Ukraine.
Yeah, I think it's a really good question, Reggie. I'm very interested in it. In the Syrian crisis that's gone on now we're in our 12th year of it as an international community. The International Criminal Court's never had jurisdiction over the Syrian conflict because Syria is not a state party. There's no way the Security Council ever refer it because twice at least that I know of, the French tried to secure a Security Council referral. The Russians and the Chinese joined together to veto that. So we're sort of reliant on states at the national level to take seriously their obligations to investigate allegations of war crimes, crimes against humanity or genocide, especially when they had custody of individuals from the Syrian conflict in their own physical territory. Now, some states, and Germany is an exemplar here, take that obligation way more seriously than others. The Americans, and I think this is a more honest position than Australia's, Americans say, well, we're not going to do that. We're not going to prosecute anybody. What we're going to do is we'll be really proactive about the basis on which people have come here to take up residency, the visa status that they have, and they've got to make some declarations. You've seen that on your entry forms into the US. You ever committed an offence, and of course you say no, but then you need to think about it if you have, and you say no, and you get discovered. Uncle Sam will come down on you like, as he should, ton of bricks. So they use the immigration laws very proactively. We will deport anybody who's told us an untruth about their wartime involvement. Here, we say we've got this legislation in the Commonwealth Criminal Code, particularly Division 268, that implements all the crimes in the Rome Statute, and Australian courts have jurisdiction over those offences, all the war crimes in international and in non-international armed conflict. Australian courts can exercise jurisdiction over those offences on the basis of universal jurisdiction. That is, doesn't matter where in the world those offences occurred, it doesn't matter the nationality of the perpetrator, it doesn't matter the nationality of the victims, as long as there is some connection to Australia, the person is here.
Yeah.
But we've never, ever utilised it. Now, the Office of the Special Investigator is tasked with undertaking a criminal investigation of alleged ADF war crimes in Afghanistan, but that's not on the basis of universal jurisdiction. Even with so-called Captain Dragan Vasilkovic, an Australian national who went to the Balkans to fight with a Serb paramilitary organisation against Croatians in the Krajina region of Croatia. And he allegedly perpetrated war crimes, and the Australian government didn't even bother investigating him. It wasn't until Croatia requested extradition that case was ever litigated in Australia. So I feel like we're not as honest as the US, and we're certainly not as principled as the German.
Yeah.
Yeah. So on Ukraine, I mean, I think the ICC will never be able to deal with everything that happens in Ukraine, and the ICC will yearn for countries like Germany to take seriously their national obligations so that it's a collective effort.
And particularly when you see the mandate of the Office of the Prosecutor, who go after the most responsible for the most serious crimes, but what about all the others? And I remember that from my day as well. We often interviewed and used as witnesses people who had committed crimes themselves, horrific crimes, in order to go after and be able to get a successful prosecution for those most responsible for the most serious crimes. So it's really a universal responsibility, isn't it? Yeah. Any more questions in the room? There was one here.
What am I, chopped liver?
Exactly.
You've had
You'd be lucky you're not Ukrainian, you'd be going back there.
I had a question before, but I just can't, I'm tempted to now ask, just following on from that discussion. Does that mean, will we ever see Putin indicted by the ICC? It seems like a simple question, but will this happen in practice, do you think?
Well, possibly. He will only be the subject of an arrest warrant at the ICC if the prosecutor is satisfied that he's got enough evidence to actually justify seeking approval from the judges to issue that arrest warrant. And whether there's no trial in absentia at the ICC, so whether he's ever taken into custody and transferred to the Hague, then of course, who knows? You can't say one way or the other. But the indictments, if an indictment is issued, it will be issued on the basis of allegations of genocide, crimes against humanity, and/or war crimes, not the crime of aggression. So the ad hoc international tribunal is more promising. I wouldn't say it's going to happen. More promising for dealing with the invasion itself and all the consequences that flowed from that than the International Criminal Court is on Putin or on any other of the senior decision makers, if there are any others in the Russian elite.
I suppose following on from that as well, if you look at the arrest warrant for al-Bashir that was issued while I was there, and he was the president of Sudan, and it was issued for, well, genocide in the end as well. And he was in power for a long time, but there was the restriction of not being able to travel to countries which were part of the ICC. He did travel to a few, South Africa, I think, and Uganda, a few friendly countries for him. But imagine a head of state not being able to go to London or New York, or New York was a different story, but London and, you know, the Netherlands or wherever you want to go.
Paris.
So Paris.
Why would
So
you
there
want
was
to go to Netherlands?
exactly, that's right. Because unless you want to go to the Hague and surrender yourself. But there is that restriction on someone who's a head of state that has a arrest warrant issued against them that they can't move. Now, on top of that, an ICC arrest warrant doesn't have a use by date. And what happened in Sudan? He was overthrown. Now there's talk, and I don't know whether it's going to happen, there's talk of him being offered up to the ICC along with other people that he worked with. There were arrest warrants out against as well. So it's a waiting game. Whether or not that will happen with Putin or not, we don't know, but there's certainly a derivative effect of issuing an ICC arrest warrant. But of course it needs to be on the basis of that there's a reasonable basis. And
Just quickly, Reggie, that last scenario I think is really quite fascinating.
Is this your question, Matt, or is this
No, my
something
question's got to do with neutrality,
Oh,
so that's a bit different. So the sanctions are starting to hurt. There seems to be internal unrest in Russia. If there is a change of regime in Russia, we might see a circumstance such as we saw with the ICTY in Croatia, that you start cooperating with us and we will fast track your admission into the EU, or in the case of Russia, we will give you those grants to kickstart your economy once Putin is gone, if you transfer him to the Hague. So there are some scenarios of which, as you said, that doesn't expire. Once, if there is an indictment, there might be incentive there for opposition in Russia to perhaps send him to the Hague.
Yeah, not completely beyond the realm of possibility.
we're a little bit over time.
You
If
can give
this-
Matt I think you should give him his chance.
All right. Matt,
He's busting.
go. I know. he
It's all
is.
right, if we
It's
cut
just-
enough time, it's fine, I can have the
The boy
conversation
comes
later.
through the floor. He's just, who knows what'll happen if he doesn't get the
Easy
chance.
tiger. All right, go.
We know what happens, and we know the problems with NATO entering the war, whether that be by a no-fly zone or boots on the ground. But a conversation that we sort of started at a similar forum that we had was about the provision of lethal and non-lethal aid to Ukraine and what that means for neutrality. And I'm really interested in what the legal ramifications or aspects are of Western countries sending gear essentially to Ukraine and what that means for their neutrality with respects, especially with respects to Russia and aggression.
Yeah, thanks, Matt. Well, as you know, did a little bit of work after last Thursday to try and understand the situation a little bit more. And the
It's a bit
article,
of a Dorothy Dixon.
beautiful. Now I'm sort of not sure I should have pushed so hard for you to be able to have your chance to ask the question, but it is a really interesting question. And the article you sent through to me was very helpful. So the suggestion by some of the key leading commentators in this field is that the law of neutrality's undergone a shift in the post-World War II era. The law of neutrality really dates back to, at least in terms of international codification, back to Hague Conventions of 1899 and 1907. And under the law of neutrality, states which did not want to become parties to the conflict, to an armed conflict, had to be really careful about what level of assistance, if any, they would provide to either side. And if you actually went so far as not to contribute your own armed forces, but weapons and ammunition and fighter jets and the means by which one party can fight the war, you are in violation of the rules on neutrality and can be considered by the opposing side a co-belligerent and therefore, attackable. But the argument is that post-World War II and the UN Charter and the whole sort of establishment of the collective security system, Security Council and General Assembly playing a role to respond to unlawful uses of military force, the law on neutrality doesn't work the same way, because if you're a member state of the UN, you have an obligation to follow Security Council directives if the Security Council is capable of taking a decision. More often than not, the General Assembly is making recommendations in the absence of an ability on the part of the Security Council to reach a decision because of the use of the veto. And so here, in relation to the Ukrainian situation, the argument is that because Russia is the aggressor in violation of the prohibition in Article 2, Paragraph 4 of the UN Charter that I referred to earlier, and Ukraine is entitled to defend itself, other member states of the UN are also entitled to support Ukraine in the defence of itself without becoming co-belligerents in the armed conflict with Russia. Russia might not see it that way, of course, but there is a very strong legal argument that by sending, whether it's anti-tank missiles or whether it's fighter aircraft or whatever it is, to Ukraine to enable Ukraine to more effectively defend itself, Russia can't attack the state that's providing those means. If any of those states put troops on the ground or started flying their own jet aircraft to blow up Russian targets, well, of course it's on, and that's what NATO wants, not real keen to see happen. Yeah. Thanks, Matt. Very nice question.
That will have to be the final
Let it be.
question.
The
Yes,
final
yes. We did start a little bit late, but we've gone over, and I apologise for that. There's a couple of unanswered questions, but that will open the door for the next forum, I hope.
Please send our apologies online.
Yes, I think they're probably still watching. So thank you very, very much to our panel, Dr. Matt Killingsworth, Professor Tim McCormack, Dr. Tamara Wood. Thank you for your attendance here. Thank you for everyone online. We've had a big turnout online, which has been wonderful. And we hope to see you next time. Thank you.